Assalamualaikum madam, my name is Syarifah Nur Ain Najwa BINTI Nazeri 047250 is going to present the question that have been assigned. The question is, GD, an advocate and solicitor, has been practicing as a sole practitioner for 20 years in the areas of litigation and conveyancing. His practice has been good in early years. However, due to recent COVID-19 pandemic, followed by the mandatory lockdowns and his poor heart condition, GD gave less and less attention to his office work. Subsequently, his practice has been badly affected, resulting in reduced billing and reduced income. In order to cover his increasing medical and office expenses, GD resorted to using the stakeholders' money in his firm client accounts. A complaint has been filed with the disciplinary board by a client, Joshen, who alleged that the balance of the purchase price due to him as a vendor in a conveyancing transaction has still not been released to him, even though the matter was completed several months earlier. 6 months after filing the complaint with the board, Joshen withdrew the same on the ground that he has reached an amicable settlement with GD and that he has received a great portion of the balance purchase price. Based on the fact above, does the withdrawal of the complaint by Joshen absolve GD of professional misconduct, and how does Legal Profession Act 1976 ensure that GD conduct may still be investigated? Second, discuss GD professional conduct with particular reference to the Solicitor Account Rules 1990 and in relation to general ethical rules regulating the legal profession. I'm going to explain the first question, which is based on the fact above. Does the withdrawal of the complaint by Joshen absolve GD of professional misconduct, and how does the Legal Profession Act 1976 ensure that GD conduct may still be investigated? The withdrawal of the complaint lodged to GD by Joshen will not absolve GD professional misconduct. This is because the complaint is already lodged, and according to Rule 8 of Legal Profession Disciplinary Proceeding Rules 1994, the disciplinary board will forward the complaint to the Bar Committee for its consideration on whether to intervene, i.e. to ascertain whether there is merit, and proceed with the complaint on its own motion. This means that even Joshen withdrew the complaint lodged on GD, but the complaint will still going on to be continued with the discretionary power held by the disciplinary board. This can be referred to the case of Mazaini binti Zainuddin 2007 and also the case of Majlis Peguam Malaysia against Lim Yin Yin 2018. Where the withdrawal of the complaint lodged does not absolve the professional misconduct done by the solicitor. How does the Legal Profession Act 1976 ensure that GD's misconduct may still be investigated? The conduct done by GD must be a conduct which falls within the definition of misconduct as provided under Section 94, Subsection 3 of Legal Profession Act 1976. Joshen must lodge the complaint to the disciplinary board. The complaint must be made in writing and include all supporting documents to substantiate the allegation, also a non-refundable administrative fee. Joshen needs to ensure that the supporting document includes proof of appointment of counsel and few other documents. These have been stated in Section 99, Subsection 1 of Legal Profession Act 1976. Third, in addition, Section 99, Subsection 3A provides that the complaint is valid for a period of 6 years from the date when the right of action to bring to the complaint. So, the complaint lodged by Joshen against GD will be valid for a period of 6 years, and disciplinary board still can proceed with the disciplinary proceedings. So, let's discuss on GD professional conduct with particular reference to the Solicitor Account Rules 1990 and in relation to general ethical rules regulating the legal profession. It is GD responsibility and duty to pay money that was received from the client into the client account without any delay. These have been provided under Rule 3 of Solicitor Accounts Rule 1990. Furthermore, it is notwithstanding with the rule that permits the withdrawal of a client's money for the payment to or on behalf of the client, which provided under Rule 7, subsection 1, subsection 1st of Solicitor Account Rule 1990. An advocate and solicitor has duty not to use the client money to settle his liability to some other clients. These have been stated in the case of Gina Nasigaran, anak lelaki Parajasinggam against Public Prosecutor 1997. Rule 60 of Legal Profession, Practice and Etiquette Rules 1978 does explain on the use of word consultant and associate. In this case, GD had been practiced for a time which entitled him to be a master of the population. Hence, it is become his responsibility to show a good example to the population in order to protect the dignity of the profession. The conclusion. It can be concluded that the withdrawal of complaint lodged by Joshen towards GD does not absolve the professional misconduct on GD's part, and it can be said that the complaint can still be processed by the disciplinary board if there is merit on the said offence. Plus, an advocate and solicitor governed by Solicitor Account Rules 1990 when dealings with the client money and failure to comply with the regulation means the said advocate and solicitor engaged in a professional misconduct. This applies to GD's situation as an advocate and solicitor. That's all from me. Thank you, Madam.